Welcome back, everyone. Today we'll be talking about products liability, allocating risk and responsibilities. Product liability law addresses how risks and responsibilities are allocated between manufacturers, sellers, and consumers. This lecture explores government regulation of product safety, the evolution of products liability law, and the intersection of contract and tort law in protecting consumers from dangerous products. This area of law addresses fundamental questions like who should bear the risk when products cause harm, and what responsibilities do businesses have to ensure product safety. Product liability cases often involve manufacturing defects, design defects, warning label defects, or breach of warranty claims. We'll also review government regulatory bodies like the Consumer Product Safety Commission and the National Highway Traffic Safety Administration, while tracing the evolution of the products liability law through contract and tort principles. Throughout this discussion, we'll analyze real-world cases that illustrate the complex balance between business interest and consumer safety. Products liability law has evolved from primarily contract-based remedies to include tort principles, expanding manufacturing responsibility significantly. So think about this as we go through this chapter. How does this evolution reflect changing societal values? A good place to start in this conversation is government regulation of product safety. The Consumer Product Safety Commission, the CPSC, is a federal agency established in 1972. It protects public from unreasonable risk associated with consumer products. It enforces consumer product safety standards. And a recent example of this is in March 2023, the CPSC announced Peloton would pay $19 million in civil penalties for failure to report treadmill defects. Another government institution is the National Highway Traffic Safety Administration. This governmental agency regulates vehicle safety standards. They investigate safety defects in motor vehicles. They oversee recalls. In a recent example, in December of 2024, the NHTSA expanded investigation into Tesla's autopilot systems after multiple crashes. Now, there has been quite an evolution of products liability law. Pre-1900s, the caveat emptor was, let the buyer beware. Then in 1916, McPherson versus Buick Motor Car eliminated privity as a requirement. Then, several years later, in 1963, Greenman versus Yuba Power Products resulted in a strict liability doctrine. And in 1965, there was a restatement, a second of torts, Section 402A. And then again in 1997, a restatement, third of torts, emphasizing products liability. There are several types of product defects. Manufacturing defects, which are individual products deviating from the design. Design defects, this is when entire product lines are inherently dangerous. And warning defects demonstrate inadequate instructions or warnings. Key stakeholders when we're talking about product liability include manufacturers, sellers, consumers, and regulators. And so the central question is, how should risk and responsibilities be allocated? We have several legal foundations: contract law, tort law, and statutory regulations. The first case that we'll use to illustrate some issues in the product liabilities conversation is the Bic lighter cases. This is surrounding fire liability and design evolution. The first case, Glover versus Bic Corp, was in 1998. So a man with a Bic lighter died in a kitchen fire. The Bic lighter was in his shirt pocket and it ruptured under the pressure of the kitchen fire. The lighter shell separated, creating a flamethrower effect. The outcome of this was that the jury awarded $1.3 million in punitive damages. And so the theory of liability here is that design defect, plastic construction, could not withstand normal pressure of the fuel. The second Bic lighter case was Willard versus Bic Corp in 1991. A woman was severely burned in a boat explosion fire. A friend attempted to light cigarettes seconds after refueling the boat. The lighter allegedly sparked gasoline vapors. So the legal issues here are adequacy of warnings regarding use near flammable vapors. Whether foreseeable misuse creates liability is also another legal issue in this conversation. The significance in this case was that it expanded manufacturer responsibility for foreseeable environments of use. The third case in the Bic lighter scenarios or cases is Todd versus Society, 1995. An unsupervised 4-year-old started a house fire. The child found the Bic lighter left on a table by the parent, despite warning to keep out of reach of children. The legal question is child use of lighters foreseeable misuse? Now, this case had pretty big industry impact. It led to Consumer Product Safety Commission focusing on child-proof lighters. So there was an evolution of Bic's response. In 1992, Bic introduced child-resistant designs with dual action mechanisms. Then in 1994, the CPSC mandatory standard for disposable lighters was enacted. And then in 2024, recent CPSC data shows 80% reduction in child play lighter fires since this standard was implemented. Key takeaways for manufacturers are: 1, the foreseeable misuse doctrine. Companies liable not just for intended use, but foreseeable misuse. 2, warning adequacy. Warnings alone often are insufficient as a defense against design defective claims. 3, regulatory influence. Litigation often precedes and drives regulatory standards. 4, design evolution. Successful companies adapt designs to address revealed safety issues. And 5, risk utility analysis. Courts increasingly apply test asking if safer alternative designs were feasible. Next, we'll talk about pharmaceuticals. In the Wyeth versus Levine implications, Diana Levine received Phenergan via an IV push method. She developed gangrene, resulting in an arm amputation. The drug's label warned of risk, but did not prohibit IV push method. The Supreme Court ruled 6-3 against Wyeth. Key implications here: it affirmed the importance of detailed warning labels. It established ongoing responsibility to update warnings. It rejected federal preemption arguments. In more recent develops in 2023, Johnson & Johnson agreed to pay $8.9 billion to settle talcum powder lawsuits. Another recent development is The major generic manufacturer Teva paid $225 million in 2024 to settle opioid claims. P.J. O'Rourke said in Bloomberg Law in 2024, "If you think healthcare is expensive now, wait until you see what it costs when it's free." GMOs, or genetically modified organisms, are organisms whose genetic material has been artificially altered using genetic engineering techniques. It involves inserting DNA from one species into another to transfer specific traits. This is different from traditional breeding, which relies on crossbreeding related species. Common modifications include pest resistance, herbicide intolerance, enhanced nutritional content, and even improved shelf life. But the market response has not always been favorable. Major retailers like Target, Kroger, Safeway, and Trader Joe's refuse to sell genetically modified salmon. Consumer demand has been driving transparency in non-GMO labeling. In 2021, the USDA implemented mandatory bioengineered food disclosure. And in 2023, over 75% of processed foods in the U.S. contained GMO ingredients. So some current controversies regarding and surrounding this is in 2024, environmental impact litigation against the EPA regarding new GM mosquito releases in Florida. There's ongoing debates about adequacy of safety testing, questions about patent ownership of the genetic material, international trade barriers based on differing GMO regulations. Think of it like this. GMOs are to agriculture what autotune is to music. Unnatural, but probably here to stay. And just like with music, the debate isn't about whether the technology exists, but how we use it. Still talking about GMO products, the recombinant bovine growth hormone, or BGH, is the genetically engineered version of BST. And this was developed by Monsanto, which is now Bayer, and FDA approved in 1993 to increase milk production in dairy cows. And in fact, it increased milk yield by 10 to 15% when it was injected into cows. But there was a labeling battle. Monsanto sued dairies that labeled milk as BGH free, or BST free. The legal argument was that there was no detectable difference between milk from treated and untreated cows. Now, the FDA's position was that voluntary labeling permitted with context statement that no significant difference has been shown would be acceptable. In 1996, there was a case with the International Dairy Foods Association versus Amistoy, and the Second Circuit struck down Vermont's mandatory BGH labeling law. The court held state could not compel speech based solely on consumer curiosity. There's some key legal principles illustrated in this case. First, commercial speech doctrine, the First Amendment protections for truthful commercial information. Second, compelled speech, constitutional limits on government-mandated disclosures. Third, federal preemption, tension between FDA policy and state-level labeling requirements. And fourth, market solutions, consumer preferences driving industry practices beyond regulatory requirements. An important area to address when discussing the topic of product liability is the automotive industry. The National Highway Traffic Administration, the NHTSA, plays a crucial role in regulating vehicle safety standards and investigating safety defects in motor vehicles, as demonstrated in both the Ford Pinto and the Volkswagen clean diesel cases. So the Ford Pinto case in the 1970s, there was a cost-benefit analysis. It was $11 per car fix versus the expected lawsuits. A Ford memo calculated human life value at $200,000. But there was an ethical failure of prioritizing profits over safety. The Pinto case raises profound ethical questions about how companies should value human life in design decisions. From a free market perspective, Ford weighed financial cost against potential liability. A utilitarian approach would consider the broader societal impact of unsafe vehicles, while a deontological view would focus on the moral duty to protect consumers regardless of the cost. Now, Volkswagen's Dieselgate is still ongoing. It started in 2015, so it's 2015 to present. It installed defeat devices to cheat emission tests. There were over 11 million vehicles worldwide affected. The cost of Volkswagen, $30+ billion in penalties and settlements. From an ethical standpoint, both cases represent serious breaches of corporate responsibility. Ford's actions directly endangered lives, which most ethical frameworks would consider more serious than environmental harm. However, the scale and deliberate nature of Volkswagen's deception affected millions worldwide. It represents a massive breach of trust in environmental responsibility. And it's worth mentioning a third example here, Tesla. Tesla's full self-driving controversy started in 2023. There are questions about marketing versus actual capabilities. The NHTSA investigated and is still investigating cases into multiple crashes. In 2024, there was a recall of 2 million vehicles to limit autopilot use. The Protection of Lawful Commerce Act. It was passed in 2005 to shield gun manufacturers from certain lawsuits. It provides immunity when legally manufactured products are criminally misused. And it also provides exceptions for defective products or knowing violation of laws. There's a few key cases here. Soto versus Bushmaster. The Sandy Hook families used marketing liability exception. 2024, the Supreme Court declined to hear the challenge to the law maintaining immunity protections. There's some ethical considerations here. This balances the Second Amendment rights against public safety. It questions whether firearms should be treated differently than other products. And the debate over manufacturer responsibility for foreseeable misuse. Gun advocates like to say, gun control means hitting your target. Everything else is just politics. This law still remains controversial. Advocates arguing it prevents frivolous lawsuits, and critics contending it provides unprecedented immunity to a single industry. I mentioned Sandy Hook in the last slide, and many of you may remember that, but it's worth spending a little bit more time discussing this. The families of Sandy Hook victims argued that Bushmaster knowingly marketed and sold the XM-15, a weapon designed for military use, to civilians who were unfit to operate it. They claimed the weapon posed an unreasonable risk outside specialized institutions like armed forces and law enforcement. The lawsuit centered on negligent entrustment claims, arguing that selling such weapons to civilians was inherently negligent given their high risk of mass shootings, potential, and minimum utility for hunting, sporting, or self-defense purposes. The case continues before the Connecticut Supreme Court after a lower court dismissed claims based on the PLCAA. The outcome could significantly impact how firearms are marketed and sold to civilians. Now, there's a new approach called a performance-based regulation. And this came about from Stephen D. Sugarman's model. And some of the components of that were that manufacturers must meet specific health and safety metrics, financial penalties for missing benchmarks, and allows flexibility in how companies meet the standards. The advantages were it provided a results-oriented approach, preserves business innovation, and clear accountability. There's alternative approaches, taxation, and this internalizes social costs through price signals. Another alternative approach would be litigation, compensating victims and creates deterrence. Command and control through direct government mandates. Contract law and the Uniform Commercial Code has several key components. Talk about the breach of warranty claims. The express warranty, this is where the seller's specific promises about the product. If it's an implied warranty of merchantability, the product works as expected. If it's implied warranty of fitness, the product suits buyer's particular purpose. Now, in this case, the Kent Wool versus NetSuite case, this highlights the distinction between goods and services in contract law. The court viewed the agreement as primarily a service contract rather than a sale of goods, placing it outside of UCC governance. This distinction is crucial for determining which warranties apply and what remedies are available to the injured party. Implied warranties under the UCC. Merchantability. Every merchant seller implicitly warrants that goods are fit for their ordinary purpose and match their description unless specifically disclaimed. This ensures basic functionality and quality. Next is fitness for a particular purpose. When buyers rely on sellers' expertise to select appropriate goods for specific needs, sellers implicitly warrant the goods will serve that purpose. This requires buyer reliance and seller knowledge. For software, merchantability means the program functions as described, while fitness for a particular purpose applies when software is recommended for specific business applications. In Kent Wool versus NetSuite, the implied warranty claims were dismissed because the UCC did not apply to their service-oriented contract. However, Kent Wool had relied on NetSuite's claims of manufacturing industry experience and integration capabilities, which would typically support a fitness for particular purpose warranty under the UCC. Next, let's talk about prescription drug liability. Since 1999, more than 165,000 people died of addiction to prescription drugs such as OxyContin and Percocet. In 2008, Cellophane Inc. pled guilty to aggressively marketing its powerful painkiller, the fentanyl lollipop, to family practitioners and specialists for off-label conditions ranging from headaches to wound dressing changes that had not been approved by the FDA. Joey Caltagirone died of an overdose in 2014 after taking nearly 6,000 fentanyl lollipops over 6 years for migraines. Now, in cases like Caltagirone's, families can sue both the drug manufacturer, Cellophane, and the healthcare providers who prescribe the medication. Liability depends on warning labels, prescriber warnings, and marketing practices. In the actual case, Cellophane's claims were dismissed in March 2017 based on the learned intermediary doctrine through appeals, but appeals were still pending as of 2017. Autonomous vehicle liability, aka self-driving cars. There's some novel legal questions when we have this conversation, like who's liable when AI makes driving decisions? How should vehicles be programmed for unavoidable accidents? Should government regulate algorithms? In 2016, Joshua Brown became the first known fatality involving a self-driving car when his Tesla failed to apply brakes when a tractor-trailer turned in front of him. So we have to determine defectiveness. Determining defectiveness requires examining whether the self-driving system performed as designed and whether that design incorporated reasonable safety standards. Critical ethical questions arise about how self-driving cars should be programmed to handle unavoidable accidents. Should they prioritize passenger safety or minimize overall harm? The incident raises questions about whether the government should mandate safety programming standards or leave decisions to manufacturers and market forces. This leads us to the trolley problem. Self-driving cars present modern versions of the classic ethical trolley problem. Should vehicles be programmed to protect passengers at all costs, or should they sometimes sacrifice the driver to save more lives? These ethical questions have real programming implications for manufacturers. Government agencies face unprecedented challenges in creating appropriate safety standards for autonomous vehicles. The balance between encouraging innovation and ensuring public safety remains very difficult, with questions about who should make the critical programming decisions: manufacturers, regulators, or consumers. In 2023, the NHTSA established new crash reporting requirements for autonomous vehicles, and in 2024, California approved expansion of driverless taxi services despite concerns. There's still ongoing debate about federal versus state regulations surrounding this. Augmented reality, or AR games, overlay digital content onto the real world, creating immersive experiences that blend physical and virtual environments. While these games offer innovative entertainment, they also introduce unique legal challenges. When Pokemon Go launched in 2016, it created new liability questions as users suffered injuries while playing, some falling into ditches or crashing vehicles. Potential claims against game developers could include failure to warn of foreseeable risks, negligent design encouraging dangerous behavior, or defective product claims if the game malfunctioned. Developers might defend themselves by arguing user misuse, assumption of risk, as users choose to play while walking and driving, or that warnings were provided. The evolving nature of augmented reality technology presents novel legal challenges in determining the scope of developer responsibility for real-world consequences, particularly concerning user safety and liability. As AR technology continues to evolve, so too will the legal frameworks governing its use. Balancing innovation with user safety and legal compliance will be crucial for the sustainable growth of AR gaming. Now, there are global product safety dilemmas as well. The DDT example is one. DDT effectively controls mosquitoes that spread malaria and Zika. It was banned in the U.S. since 1972 due to environmental and human health concerns, but it is still used in 23 nations for malaria control. From public health officials, there are 300 to 500 million new malaria cases every year. Environmental advocates state long-term ecosystem damage. And in terms of economic reality, alternative pesticides cost 2 to 3 times more. This ethical dilemma pits immediate public health benefits against long-term environmental and health risks. Different ethical frameworks yield different conclusions. Utilitarians might support limited DDT use where malaria is endemic if it saves more lives than alternatives, while deontologists might focus on the duty to avoid known harmful substances regardless of the benefits. Let's talk about case studies in corporate culture for a minute. Anton Yelchin was an actor who was killed in 2016 when a recalled Jeep rolled down the driveway. Another example is GM's ignition switch scandal. And CEO Mary Barra changed the culture of GM to address defects of this ignition switch. And in 2016, Samsung Galaxy Note 7 rushed their product to market, and that led to dangerous battery issues causing fires. In 2023, Ford recalled 870,000 F-150 trucks for unexpected parking brake activation. 2024, Toyota recalled 381,000 Tacoma pickups for potential drive shaft separation. The take-home here is that a company's approach to recall tells you everything about its values, especially how quickly they send the recall notice after you've had the accident. Let's talk about local regulation of product safety and how that intersects with global challenges. In 2016, Albany, New York enacted the Toxic Free Toys Act, banning the sale of children's products containing any amount of lead, mercury, arsenic, cobalt, benzene, cadmium, or antimony. This ordinance exceeds federal standards, with violations resulting in civil penalties of anywhere from $500 to $1,000. Now, such local laws create enforcement challenges given international nature of commerce. What happens if the toy was shipped from overseas? They can also negatively affect local sellers who must comply with stricter regulations than companies in other jurisdictions, potentially leading to higher prices or limited product selections. Despite challenges, local laws can serve as an important policy step by functioning as test cases for larger regulatory actions. If successful, other jurisdictions may adopt similar measures, eventually creating enough pressure for uniform national standards. Let's talk a little bit more about local versus federal product safety regulation. There's regulatory disparities. The EU restricts 1300 plus chemicals in cosmetics. The FDA banned only 11 cosmetic ingredients as of 2016. The Collins-Feinstein bill proposed just 5 annual chemical evaluations. Fitbit users have reported inaccurate heart monitoring during intensive exercise and sleep tracking. Potential legal actions include breach of warranty claims or products liability if inaccurate health monitoring leads to injury. When Samsung's corporate culture rushed the Note 7 to market, it may have contributed to the battery explosion problem. with pressure to rush products to market, potentially compromising safety testing and quality control processes. These cases highlight how rapidly evolving technology creates new product safety challenges. Regulatory frameworks often struggle to keep pace with innovation, creating gaps that might be addressed through litigation, voluntary industry standards, or consumer pressure. Companies must balance competitive market pressures against thorough safety testing to avoid costly recalls and reputation damage. In summary, the key takeaways from this chapter are: Products Liability Law balances innovation with consumer protection. Corporate culture significantly impacts product safety decisions. Regulatory approaches vary widely across jurisdictions. Emerging technologies create novel liability questions. And ethical considerations should guide both regulation and business decisions.